So, distinguished guests, fellow panelists, ladies and gentlemen, a very good afternoon to all of you, and welcome on behalf of the Law Association of Trinidad and Tobago and the Equal Opportunity Commission. We are exceedingly pleased that you could join us, both live here and online, to commemorate World Human Rights Day, the day that has been chosen to commemorate and honor the adoption of the Universal Declaration of Human Rights, which was adopted on December 10, 1948. In honor of that event, our panel discussion this afternoon is intended to introduce to you some of the more specialist dimensions of the right to equality in general, and more particularly its treatment and application in the Equal Opportunity Act of Trinidad and Tobago. Given that the subject of equality is one that confounds even the most specialist lawyers and scholars in the field, we hope that the presentations and discussions planned for this event will benefit you both generally and in your practice, and particularly because, and especially from the presentation of Ms. Sivaran Sweet, we hope to get into the nuts and bolts of the remedy under the Equal Opportunity Act. To start with a brief overview of the program, we will briefly consider just a few, we'll just have a few presentations, but partly because we want to reserve some time for our discussion. I will begin with a general overview of the equality right as it's been, both as it's incorporated in the Trinidad and Tobago Constitution, and as it has been interpreted both in your jurisprudence and in the jurisprudence of Caribbean courts. I'll be followed by Ms. Sivaran Sweet, who will have a more focused discussion of the remedy under the Equal Opportunity Act, and as well with references to emerging jurisprudence generated by the Equal Opportunity Tribunal. And finally, our featured speaker, Mr. Maraj, will complete the picture with a more generalized examination of remedies in the area of human rights litigation. So in the time that's remaining to me, well, it wouldn't be a, all right, yes. It wouldn't be a proper event if we didn't have some technological challenges. But what I hope to accomplish this afternoon is quite simply, first of all, a brief overview of the nuts and bolts of the equality provisions in the Trinidad and Tobago Constitution, particularly Section 4B and 4D, which is no doubt familiar to most of you here and following online, as well as the shortcomings of the formal notion of equality, which is how we tend to interpret it in the Caribbean. And then, as a jump off from that, to look at the substantive notion of equality, and both how that has been interpreted by scholars and as that concept has been applied in some of our jurisprudence. In the end, my ambitious goal in this very limited time is to not so much dwell on the nuts and bolts, but to urge reflection on the tremendous promise of the right to equality and what it is meant to achieve. So as my first slide here, I have Article 1, or part of Article 1 of the Universal Declaration of Human Rights, which says all are born free and equal in dignity and rights. This is the lodestar, not just of the Universal Declaration, but almost every international treaty, human rights treaty in which it appears, as well as countless domestic systems, human rights systems, that is, and constitutions. So it's not just an aspirational goal, it is an enforceable right. But having said that, as our jurisprudence reveals, there is tremendous contestation, both around the contours of this right, as well as some degree of uncertainty as to what the concept of equality actually entails. So, not sure why this is happening, but briefly, so briefly I wanted to just start off by looking again at your section 4B and 4D of the Trinidad and Tobago Constitution, which speaks to, first of all, the guarantee of rights on certain grounds. Right, section 4. So the recognition and declaration of certain rights without discrimination, and then specifically naming in 4B the individual right to equality before the law and protection of the law, and the right of the individual to equality of treatment in 4D. Starting with, finally, good. So equal protection of the law. 4B is actually conceptualized as requiring that laws themselves are equal. So laws themselves must not classify, but must treat equally. And so just wanted to mention a few key points around 4B as it has been interpreted by the courts. First of all, it's a freestanding right, meaning it's not limited by the enumerated grounds in the introductory word. So when you see sex, race, whatever, those don't limit the categories of classification, or they're not the sum total of protected statuses under the Constitution. I say here there's no requirement of mana fides, and that's because this was a point that engaged a lot of early jurisprudence in Trinidad and Tobago. But since Maraj, I think it's been quite accepted, and not the seminal Maraj case, but the more recent one, Public Service Appellate Tribunal, I think, it's been accepted that there's no requirement of bad faith. And importantly, where legislation draws distinctions, these must be justified. And to do so, it must be established that distinctions or differences in treatment serve a legitimate aim and are rationally connected to that aim. And it's for the state to prove that justification. Now, I want to return to some of this, but let me quickly look at 4D. So 4B is about the law, and whereas 4D is about treatment. So equality of treatment, in other words, this is the right that is often thought of as being synonymous with non-discrimination. And so public authorities under the Constitution, it speaks to the public authorities as distinct from the Equal Opportunity Act. The rationale here, or the elements of this right here, first of all, just briefly, and I set out here, but the Anissa Webster case, which goes into a lot of detail here, but in establishing a claim under 4D, you must show, first of all, different treatment in relation to a similarly circumstanced person. And that opens up the requirement of the comparator, which is something that has caused so much difficulty in our jurisprudence, not just here, but generally in equality law. And so, in other words, the point of this comparator is really saying that here are two people who are similarly circumstanced, who are situated similarly, but for one characteristic, and the difference in treatment is motivated by that difference in treatment. So similarly circumstanced, you might have two people working in an organization doing the same, having the same functions, and in every way situated the same, except perhaps there might be a difference in gender. And so the complainant's allegation here is that because I am a man or because I'm a woman, I am treated differently and less favorably. And so the whole point of the comparator is to highlight this difference in treatment. In the Trinidad and Tobago Constitution, because it speaks broadly of equal treatment, there is no reference to grounds. And this was the point I was making earlier on. As compared to every other constitution in the Caribbean, where non-discrimination is limited by certain what we call protected characteristics. So you can't discriminate on the grounds of race, sex, gender, and so on. Here in Trinidad, it's an open-ended right. So there's no closed list. Now, there are interesting questions. Is it open-ended? Does it mean any ground? And those are the kinds of issues that haven't been fully settled by the courts here. And then, of course, this point of intention being irrelevant. And as I said earlier, when difference in treatment is established, then it is for the respondent state to justify any differences. So having laid out, I just wanted to get into some of the key features of the equality right, or the equality concept, I should say. And one of the key ones is this question of likeness. And what we're talking about here is formal equality. And by formal equality, I really mean procedural equality. And the whole underpinning of this right is that alike should be treated alike. If you are alike, you have to be treated alike or treated the same. And instinctively, I think, instinctively we accept this as a fundamental principle of justice. If you are all the same, then you should receive similar treatment. The difficulty with this concept, or I should say one of the difficulties, which I will come to, is determining who is alike. But just to say that the essence of procedural equality is this question of likeness. And so this is where the comparator comes in Trinidad and Tobago, because you show that difference by reference to someone who is similarly situated to you. As they explain in the Webster case, people who are similarly circumstanced, but for some characteristic. And it is that characteristic that shows the discrimination. And that characteristic is often what we will also call the grounds of discrimination. And like I said, in most Caribbean constitutions, those grounds are specified, not so in Trinidad and Tobago. The last thing, but intent, I've mentioned that a few times, discrimination can be direct or indirect. And so direct in the sense where laws or action might actually target a group or an individual directly. So you might say direct discrimination, for instance, is paying difference in pay because of gender. So this is something we hear about a lot, that women earn less than men. It might be indirect. It might be indirect where the law on the face is not directly naming a group or treating a group differently, but its effect is discriminatory. And the best example I can give of this is always coming back to Guyana, where in Guyana, sugar workers are almost synonymous with East Indian laborers, and the bauxite workers are with Afro-descendants. And so when you hear allegations by governments, depending on whoever the government is, that or the opposition, that, oh, they're discriminating against bauxite workers, that's code for saying, well, you're discriminating against black people, right? Or if you're discriminating against sugar workers, you're discriminating against East Indians. The point being that it mightn't facially name this group, but the effect is to impact more heavily on a particular racial population. And so that's what the indirect is coming to. Now, I wanted to just discuss briefly some of the conceptual challenges around this formal notion of equality. And some of them are quite easy to mention. First of all, this question of the threshold, which I earlier adverted to, which is what is like? At what point will you say people are the same? And how do you determine this question of likeness? It's not as straightforward as it seems. For a long time, for instance, throughout our period of colonialism, people were not seen as alike based on race. So if you were, for instance, an Afro-Trinidadian or an Afro-Caribbean person, slavery was justified because you were seen as lesser than. You weren't seen as equal to. So now, of course, that's different, but the same principle applies, which is what's the basis for classification? What I mean by a relative principle is that formal equality just means treating everyone the same, but it doesn't have a substantive content, meaning there's no underpinning. So if some group complains about equality, one answer under formal equality could be to level down everybody. And that's because of the absence of this substantive content. And to give you a graphic example, when in the 80s in Trinidad and Tobago, there were complaints that some of the sexual offenses laws discriminated against gay men because they only prescribed sexual offenses, same-sex intimacy between men. The 1986 amendments to the Sexual Offences Act included women. And one of our scholars at the UB said this was equality with a vengeance, meaning instead of decriminalizing and so making, raising everyone up, the law then leveled down. So women were now included with these with these prohibitions. Now the problem with the comparator, of course, is time doesn't permit me, but the problem with the comparator is one, how it forces everyone to be the same. And again, this question of if you are aiming for equality, who is the standard? And often the standard that you look at is the standard of the dominant group. I can explain this a little more as we go on, but for time, and let me just move on here. I wanted to just mention briefly about stereotyping, which is about attributing to groups of people certain expectations of how you should behave. And they can be very debilitating. They can be harmful, so women are irrational. They can be beneficial or seemingly benign. Men are strong. We know that both types or women are nurturing. We know that both types of stereotypes can be very damaging. And I wanted to illustrate this by two cases. And I'll only be able to mention them. AG against Jones was a case from St. Kitts that dealt with dress codes. Ultimately, the court said that there was nothing wrong with legislation or school rules that said young boys couldn't have long hair, whereas girls could. Now, the young boy who wanted to go with long hair was saying, look, you're treating me differently because girls can go with long hair. And what the court said, the Court of Appeal, Barrow J as then was in Court of Appeal of the OECS, was that this dress code is okay because it's simply enforcing convention. And so there's this stereotype that boys must have short hair, boys must be aggressive, boys must be thought of in a particular way, and only girls must wear makeup and girls must have long hair and so on. It seems perhaps instinctively correct, but as I argue elsewhere, it's very harmful on both sides. And often convention simply reinforces prejudice in societies. There are a whole range of cases when you enforce conventional dress codes or convention in any area. There's a case from South Africa where an Indian woman wanted to wear a nose ring, and they said at the lower courts that this is not conventional. It was recognized that just simply reinforced racial discrimination. In this case, it was gender bias. Now, 20 years later or 30 years later, I'm going fast, so I'm not sure about my maths here. In McEwen, Barrow on the CCJ, another case about dress codes where in Guyana a law prescribed dressing in a particular way. Men can't wear female clothing in public, women can't wear male clothing. And at this point, Barrow says this law is discriminatory because it's based on harmful gender stereotypes about how men and women can dress. And so this law, I think that this development in Barrow's approach shows you this awakening and this recognition of how stereotypes can actually lead to discrimination, how stereotypes can be harmful. So moving away from this notion of formal equality, which is really about treating people the same, is that of substantive equality, which is understood very differently from formal equality, which, first of all, it takes into account historic or ongoing discrimination. It focuses not on merely on treating boys and girls the same, or men and women the same, or Afro-descendants and Indo-descendants the same. It's also looking at outcome. It's saying that even if you have no barriers to let's say, women joining a particular profession, there might be other barriers because of the way the position at which they start, because of other things unique to women, childbearing responsibilities or childcare responsibilities. And so what substantive equality does is to focus on results. And this is what President Saunders had to say in McEwen, that to safeguard equality rights, courts must adopt a substantive approach. And see here, he's talking about paying regard to mere formal equality could lead to grave injustice and defeat the spirit of equality provisions. And so substantive equality is not just looking at treating people the same, it's also contemplating that you might have to treat people differently in order to get a just outcome. And I wanted to mention to you Sandra Fredman's key concept of thinking of substantive equality in a multi-dimensional way. So here, moving away from like being treated alike, and she mentions 4 concepts: redistributive, recognition, participative, and transformative. Now, what does this mean? Redistributive, about breaking the cycle of disadvantage. And this was the McEwen case that I was talking about earlier, where, so to give you the classic example of the difference between formal and substantive, in McEwen, at the lower courts, where I appeared unsuccessfully, the Attorney General in the courts, in the lower courts in Guyana, were saying this law targets both men and women. I'm soon finished. Targets both men and women. So it says that men can't wear female clothing in public, women can't wear male clothing in public. So we had our Chief Justice, who appears in first instance. He's saying, well, this law is neutral. It applies to both men and women. That's formal equality. That's formal. That's non-discrimination. Now, at the CCJ, where Mr. Mendes appeared, and so maybe that's the difference, where they accepted it, so it was no longer me. They went beyond the formal, the appearance of non-discrimination, and they looked at the treatment, how this law impacted, particularly on the trans community. So it appears neutral on the face of it. It appears neutral, but a law like this impacts heavily. And the whole point about redistribution is the disadvantage faced by the trans community. And this is what Sandra Fredman tells us, that we have to look at redistributing, removing, breaking the cycle of disadvantage. And I'm going to at the end, in 2 minutes, explain why this is about equality and not just why it's beyond formal equality. I wanted to mention briefly, this is Sandra Fredman, who pioneered this concept of substantive equality, not to be seen in abstract and formulaic terms, but should be responsive to those who are disadvantaged. This was the whole point of the McEwen decision. Now, recognition, so one is about removing disadvantage. Recognition is about promoting respect for dignity and worth. So there are multiple dimensions then to equality. So not just about disadvantage, and I think the best example of this is from Trinidad and Tobago, the Trinity Cross case, where, so this is a lot of text here, but the central point that I wanted to get across about this is Jamadar J, as he then was, whose decision on equality is eventually adopted by the Privy Council, talks about the way the focus on Trinity Cross in a multicultural society might lead people who subscribe to another religion as feeling lesser than, as feeling excluded. And so something that's not associated with a majority, or something that an award, a national award that isn't associated with one ethnic group, helps to be more inclusive of everyone. And so this is very much not just, this is not necessarily only about dignity, but this is also about, or I should say, it's not only about disadvantage, but it's also about dignity and worth. The other case, of course, is Woodall from Barbados. And this is talking about eliminating discrimination based on stereotyping. Transformative, this is Sandra Fredman's third element. And this is going beyond, here's where she expects going beyond, again, formal equality. And perhaps the best example I can give you about this, 2 minutes. The best example I can give you about this is so, but after Obama's, and I had it on an earlier slide, after Obama's election in the US, you heard stuff about, America is now a post-racial society. So does the election of a black man mean that, discrimination on the ground of race is no more in the US? And obviously we know it's not. And why is it not? It's this question of his election didn't represent transformation. What they tell you, and this is about looking as well, being careful. There are some people who can assimilate. They can behave like the majority, or they might be embraced by the majority for some reason, for other reasons. True equality looks to transforming the structures of power in society. And so, so in spite of Obama, you still have, in fact, because of Obama, I would argue, you have Black Lives Matter. And that's because the structures of society are now arrayed against his own constituency because of the resentment, perhaps, that they feel. Generally, though, at where we are in terms of transformation is always about the physical. I mentioned that not to devalue this case, which is a very important one about the access of disabled to the courts, but simply to say that it's not just about access, it's about more deep-seated change. And finally, participative. And this is where we get to full participation of all these outgroups. And this is what I have to close a number of perspectives. A theologian, this is a Jamaican theologian, who describes a just community has structures and systems that exist to serve and complete the authentic development of all persons. So participation of all. This is a legal perspective, Justice Saunders. A society which promotes respect for human rights is one that supports human development and the realization of the full potential of every individual. Professor Hugh Collins of Oxford University, and this is a kind of a utilitarian reason for full inclusion. So, I mean, think of where the discontent comes from. Think of where crime is often associated with. It's no accident it's often in the most marginalized or socio-economically disadvantaged communities, and that's because they feel alienated. And this is what participation is about, full inclusion. And finally, it's not just about everyone being the same. And this is why this is the importance of substantive equality. It's about redistributing power, changing the structures. Why is all of this, and I'll end here, why is all of this now, what's the importance of this as distinct from formal equality? Remember, as I started off by saying, formal equality is everyone being treated the same. What substantive equality acknowledges and seeks to redress is that we all don't start at the same place. There might be historic disadvantage. In Caribbean societies, there was a long history of, well, in Guyana, for instance, where indigenous peoples were completely marginalized. Indigenous people are nowhere near all of the other settled populations that came. There was slavery. So we don't start at the same place. So if you are in a physical race, and even you could put Usain Bolt at the head of Frederick Street, and put me here, and I'll get to the savannah, even though he's Usain Bolt, I'll get to the savannah before him. The point is, depending on where you start, you may not be you may not be in an equal position. Substantive equality seeks to acknowledge all of this. And by taking this multidimensional approach, the ultimate aim is full inclusion and full participation. So those are the few words I wanted. I'm sorry for perhaps 2 or 3 minutes over. Thank you very much for bearing with me. I just wanted to sort of stress where we are in terms of formal equality, but how much more important this wider concept of substantive equality is. Now we have on the program next a slight change. We have wanted to introduce to you, and perhaps this is one of the crucial aspects of our program, the Equal Opportunity Act remedy, and bringing to the Law Association and its members the nuts and bolts about this equal opportunity remedy. So our next speaker. Okay, thank you. I was going to say that you need no introduction, but for those of you on the program, there is a full introduction bio of Ms. Lynette Seabrand-Sweet, who will now come and talk to us about the Equal Opportunity Act.
Thank you very much, Dr. Bergman, and welcome to Senior Ramesh Lawrence for agreeing to be our feature here. And greetings on behalf of the Law Association of Trinidad and Tobago and the Equal Opportunity Commission. I'm wearing a dual hat here on the occasion of Human Rights Day, the 10th of December, which is the final day in the 16 days of activism against the court, 16 days of activism. Now, so I'm profoundly mindful of my time limit of 10 minutes, and also profoundly mindful of the number of slides that I have. So I am going to be racing through this, and I'm going to quickly go over some of the slides, not get too much into them. So first of all, the Equal Opportunity Act, it came into force in the year 2000, and it was proclaimed only in 2012 after there had been litigation and reached the Privy Council in the case of Surat. And we all know about Surat, and the point about Surat was that, interestingly enough, the Attorney General, who was defending the claim that the government was not proclaiming this legislation, his argument was that the legislation was discriminatory because it did not recognize the rights of gays. So that was a sort of counterintuitive argument that was put forward there. But eventually, the Privy Council determined that notwithstanding that defect in the act had to come into force. So it did come into force in the year 2008, but it wasn't until the year 2012 that the tribunal fully began to hear cases, and that was because lay assessors had not been appointed, and the lay assessors needed to sit with the chairman of the tribunal before cases could actually be tried. So there are two agencies that are created under the Equal Opportunity Act. One of them is the Commission, of which I'm the chairman, and the other one is the Equal Opportunity Tribunal. The Commission is a 5-member board, and it's an independent board. It's appointed by the President after consultation with the Prime Minister. The other agency that is created by the Act is Equal Opportunity Tribunal. And that tribunal is headed by somebody who has the status of a High Court judge, and is indeed appointed by the Judicial and Legal Service Commission, and has all of the powers and the tenure of a High Court judge. But the Equal Opportunity Tribunal must sit under the Act with 2 lay assessors. But 1 lay assessor is sufficient to found the tribunal, the completeness of the tribunal. Now, there have been rules promulgated by the Equal Opportunity Tribunal, which are known as the Equal Opportunity Rules, and matters that are not covered in the rules have to be decided with reference to civil proceedings rules, and that is specifically stated in the Equal Opportunity Rules. Now, appeals from the EOC are prohibited except in the following circumstances: points of jurisdiction that must be taken during the proceedings. Those are the other grounds of appeal. the tribunal has exceeded its jurisdiction, and so on. Largely it is that it must be on points of law. Where an appeal is on a point of fact, the full court must decide that the appeal must proceed merely on a ground of fact. And of course, where the tribunal is not subject to prohibition and they must be the prerogative writs, but no appeal lies as of right to the Privy Council. The categories, the areas in which the remedy is created, and the distinction between the remedy created by the EOC and the constitutional remedy is that the EOC remedy is available as between persons in society, between person and person, agency and agency, whereas the constitutional remedy created by the Constitution lies only against the state. So it's a very useful piece of legislation for litigating discrimination between person and person, between employer and employee, service provider and customer, that sort of thing. So these are the areas in which the Equal Opportunity Act can receive complaints, employment, education, provision of goods and services, and accommodation. And in order to access the tribunal, you must be claiming discrimination on one of these grounds here: sex, race, ethnicity, religion, marital status, disability. Now, there are two other ways of accessing the remedy, and one of them is if you are victimized by virtue of having invoked this remedy or any similar remedy, or if it is that somebody has engaged in offensive behavior against you in public, which is that somebody has committed an act which is likely in the circumstances to offend, humiliate, or intimidate another person, and it is done on the basis of it is done on the basis of gender, race, one of the status grounds, and it is done with the intention of inciting gender, racial, or religious hatred. So those are the different categories of claim that you can bring to the Equal Opportunity Commission. One big problem we've had from inception, and this is where it all began with Surat, still hasn't been cured. The definition of sex in the Act specifically excludes the LGBTIQ plus community, and that is a source of real difficulties, and it is an area in which the Commission and many of its partners and stakeholders in civil society have been agitating with the government for the inclusion of sexual orientation in the definition of sex, so that the Commission and the Tribunal can entertain claims of discrimination on this ground. So the next slide is just a graphic categorization of what that I've just said. Let's just move off of it. The Commission has an establishment of investigators. We have a team of investigators, a team of attorneys, a team of conciliators, and the conciliators operate independently in the sense that they operate under the ethic of confidentiality, and they do not share with the Commission or its other officers what goes on in the conciliation. We have communicators and we have researchers. And as I said, we have long been agitating for the amendments to the Act, where we're looking for the codification of sexual harassment as a category of sex discrimination specifically spelled within the Act. We've been looking for age as a status. We've been looking, as I said, for sexual orientation to be included. And there are certain other areas that we have also been agitating, for example, the inclusion of cohabitation and half-blood relationships within the definition of family and marital status. Very, very quickly, in terms of some of the statistics on applications which come before the Commission, basically you will see that overwhelmingly the complaints are received in the area of employment. You will see there that 80% of our complaints are in the area of employment. The other areas are the provision of accommodation, provision of goods and services, education, and so on. But the overwhelming majority of our complaints are in the area of employment. And we do have some offensive behavior as well, but not as offensive behavior, but nothing near this question of the area of employment being the one that people use to access the Equal Opportunity Commission. Now, the next graphic just shows you the demographic split in the applicants, and you will see that it mirrors very, very closely the demographics of the country, in that basically you have an equal number of Indians and Africans making applications for relief under the Equal Opportunity Commission. There is another interesting split, and that is as between complaints against public authorities and complaints against private sector authorities. Overwhelmingly, our complaints come against the public sector. So statutory bodies, the protective services, ministries, the service commissions, overwhelmingly the complaints come there, and far less so against private sector employees or private sector service providers and so on. And this may very well be because of the danger that a person always places themselves in when they make a complaint against an employer. They fear victimization, they fear being fired, and so on. So the process is that a complaint is lodged in writing, and usually the applicant does not have an attorney. And the commission is mandated to investigate every single complaint, even if it's only to come to the conclusion that the person does not come within an area or does not have a status ground. But we must investigate every complaint, and we can compel the production of information from respondents. If they do not, we can prosecute them in the magistrate's court, and the fine is $1,000 per day for every day that you have not provided the information, or $5,000 per day if you're a corporation. Because of course, you know, people they receive a letter from an agency, they throw it in the dustbin, and they feel that nothing will happen to me if I don't provide the information that I've been required to provide. So this is the sanction. Now, so after we have investigated, then the conciliation process steps in. And the conciliation would follow, and if the conciliation solves the problem, fine. But frequently, even before we get to the stage of conciliation, the commission comes to the conclusion that there is the complaint hasn't fallen within a category or a status, and then we have to do what we have to NFA the matter. We have to make a decision that no further action can be taken. Of course, this causes a lot of grief with our applicants, especially applicants who are not very sophisticated, and they just can't understand that, oh, you're ignoring my complaint, I have a complaint. And figuratively, we have to direct them to other agencies, the ombudsman, the industrial court, that sort of thing, the civil courts, because we simply cannot entertain, we don't have the jurisdiction to entertain their grievance. Now, so that basically is how the commission operates. Now, when we have not been able to secure conciliation, then the matter has to be, we have to write a report, and the matter then has to be referred to the tribunal with the consent of the complainant. And there was a little issue for a time, because the act says that the commission must initiate the complaint. So this was initially taken to be that the commission had the responsibility to prosecute the complaint. And Dr. Bultan was pointing out to me that there is nothing so inherently strange about that. For example, police officers investigate and then they prosecute. But anyway, we had a little tension between the commission and the tribunal, and eventually an arrangement was reached whereby we would initiate complaints by sending our report and by sending the consent of the complainant, but we would take no further action. How this has worked against applicants is that they must now find an attorney or try to face the court as a lay person, frequently against an employer who would have the ability to hire senior counsel, take technical points, draw the matter out, that sort of thing. Now, so there have been some problematic issues that have arisen now with the remedy, and one of them is this limitation period of 6 months within which one must make a complaint. Now, this is absolutely out of the norm in terms of litigation. For example, tort contract, it's 4 years. So this really is a fetter on the ability of a person to bring an application, the fact that you must bring it within 6 months. However, the Act does say that there are exceptional circumstances in which the 6-month period can be extended. And there is a vast body of jurisprudence which suggests that this decision to extend the time limit is a decision which vests in the investigative authority and should not be subject to review. The tribunal has taken a different view in certain recent cases, so that's a little issue there. Now, the other issue that we have is this question of Section 40 of our Act, which says that the proceedings in the conciliation must be confidential. That's an issue. And then the tribunal has adopted a fairly narrow definition of issues investigated so as to limit its jurisdiction. So that if somebody makes a claim, let's say, of discrimination on the ground of sex, in this, that, or the other particular, and then other particulars arise under the same category, which is sex discrimination, but those particular facts were not included in the initial complaint, then there is a jurisdictional issue and a tendency to strike out those parts of complaints which we do not feel is really the best philosophy to employ with litigation of this kind. So then also, we have had the recent decision, the Cascadia case, in which the tribunal decided that sex discrimination did not include sexual harassment. So if I could just dip a little bit into some of those problematic issues, talking about the question, I've already defined what is the issue with respect to the extending the period. The issue is who has the jurisdiction to make that decision and how is that to be interpreted. So for example, there was one particular case in which the complainant was unable to decipher who was the actual employer until many months after the 6 months had expired. So by the time the complainant was able to really figure out who was the appropriate employer, whether it was the service company or the entity which bore the name of the enterprise, the 6 months had elapsed, and the discretion was not exercised in favor of the complainant to permit a substitution of the proper party. So that sort of issue comes up all the time, where the question of the limitation period is applied strictly, which we feel is not really the appropriate way to interpret what is in effect a human rights statute. So the other area in which we've been having these knotty issues is that the legislation says that what can go to the tribunal are the issues that have been investigated. And one of the key problems, I'll give you a quick example. There was a particular case in which a person, I think it's Matisse versus UTT, had claimed discrimination on the basis of sex in employment. And what he complained of initially was that he had been demoted, he had not been promoted, he had not been given his increments, that sort of thing. Now, in the course of the investigation, it was discovered that the discrimination went far further, and he had been unaware of it. Somebody who had been hired at the same time as him with the same post had been given a higher salary and a longer contract. But this was only discovered during the investigation at the EOC when the information was produced by the respondent. When the matter got before the tribunal held that because these issues had not formed the initial part of the initial complaint, that those parts of the complaint had to be excised. And we felt that this was a bit of a narrow interpretation of whether an issue has been investigated. And another problem is that it is a due process argument that is frequently used to limit the jurisdiction or to excise parts of claims on the basis that it is unfair to an employer or to a respondent that something is before the tribunal which has not been investigated. So you may have a category of discrimination investigated, but maybe one particular was not investigated because it was not known. But what the tribunal has used is a due process argument to excise these parts of the complaint, which we consider to be not in keeping with the spirit and intent of how one should interpret human rights statute. Because specifically to use the due process argument, we feel is problematic. Because when a matter has been completed an investigation and it now starts before the tribunal, pleadings begin afresh. All allegations are made afresh, and the respondent has the opportunity to defend the allegation. They are not taken by surprise, and all of the evidence has to be compiled afresh, even if the evidence, the letters, and so on had been before the investigation in the commission. So for now, it to be said that it is unfair to a respondent for particular facts not to be included because they were not included in the original complaint, we feel is not in keeping with the spirit and intent of the act. Now, so we have had a number of cases that deal with these issues. One of the issues is the question of the substitution of a party. For example, we have had two particular cases that have been problematic with respect to the substitution of a party. One of them is the Rishi Maharaj Prasad case, the Cascadia case, where it was really a service company that had signed the contract of employment, but the matter was intertuned in the matter of the Cascadia Hotel, when in point of fact the employer was a service company, marketing company limited. And even though this point was not taken in the commission, and even though the personnel from the hotel, the co-directors, the same directors operating in both companies, it was held that there was the wrong party. And when the complainant attempted to invoke Part 19 of the Civil Proceedings Rules, there was an interpretation of Part 19 of the Civil Proceedings Rules that unless you have several parties, you could not substitute one party who had been wrongly named, because at the point of substitution, there would be no matter. Now, in my view, that is an erroneous interpretation. My humble personal legal view, that was an erroneous interpretation of Part 19. And one is hoping that all of these issues will, in due course, filter up as points of law and be clarified. So, again, relief was refused because even though the personnel from the hotel came to the commission, they defended the claim, they provided the investigating material. When the matter went to the tribunal, they took the point, look, we are the wrong party. The wrong party is the me, and they got through with that. So that happened in that, and that also happened in another casino case where, and this one was even more difficult because how the Henry versus Princess Entertainment. In this case, the complainant sued as follows. Princess Entertainment Corporation, Trinidad and Tobago Limited, owners and managers of the Royal Princess Members Club. So the persons who were managing this club came before the commission. They defended, they provided information and so on. The matter did not succeed in conciliation. And when it went to the tribunal, then the defendant took the point, look, this casino is not owned by Princess Entertainment Corporation, Trinidad and Tobago Limited. They are not the owners and managers of Royal Princess Members Club. Royal Princess Members Club is a members club and should have been sued by its trustees. So even though the very same persons came and they assisted in the investigation, and when it reached the tribunal, they took the point. Now, the thing is that the only way for the complainant to find out who indeed were the owners of this casino was for them to apply a Freedom of Information Act application. So there was no way for them to find out other than these digging mechanisms. But what was held was that there could be no substitution and the claim was dropped out. So one of the other, how much time do I have left? No time. All right. So let me wrap up very quickly. Take that. So, 2 minutes. 1 2 minutes. Dr. Balkan, 2 minutes. And he's the moderator. So listen, let me deal with confidentiality thing. Section 40 of the Act says that the proceedings in conciliation are confidential. And we all know what is the mischief that such a provision in any law is designed to cure. You want to shield the tribunal that ultimately has to deal with the matter from the parties' negotiations as to what they may or may not have been prepared to settle. And you also want to protect any without prejudice positions that they have taken. But what has happened is that this has been being interpreted in the tribunal to the effect that anything that is discussed in conciliation is excluded from evidence before the tribunal. Now, the logical problem with that is nobody's supposed to know what went on there. So how would anybody be able to know what went on in conciliation in order to exclude evidence? That's the first problem. The second problem is that matters may have been legitimately discovered in the investigation, and then they must become the subject of discussion in the conciliation. Well, there are several cases which have said that whenever a matter has gone to conciliation, and the phrase that is used in the cases is struggles and fuels the conciliation process. So all of that material must be left out. That definitely has to be revisited on appeal. So I'm not going to go into the particulars of the cases because we simply do not have time. I just want to spend a minute talking about how human rights statutes should be interpreted. Human rights statutes should be interpreted in the way that has been described in the case of Attorney General of Trinidad and Tobago versus Wayne Whiteman. The language of the Constitution falls to be construed not in a narrow and legalistic way, but broadly and purposefully, so as to give effect to the spirit, and this is particularly true of those provisions which are considered the protection of human rights. Not that we are saying that the Equal Opportunity Act is a constitutional document, but it definitely is a human rights statute. And there are a number of cases from sister jurisdictions. I have cited here 3 cases from Canada which have interpreted human rights statutes such as the Equal Opportunity Act, and they have definitely said that human rights legislation is of a special nature, not constitutional but not ordinary. The court should interpret such statutes in a manner which would give effect to its broad purpose. So there is one particularly poignant statement in the Cascadia decision where the tribunal was seeking to distinguish a Scottish authority which on the face of it plainly said that sexual harassment is a category of sex discrimination. Of course, all of the international conventions which Trinidad and Tobago has signed have said that. And there's a body of law which says that when a tribunal is faced with an issue, if they have a choice between an interpretation which accords with your international obligations and one which does not, you must favor the one that accords. But quite apart from that, there was a direct specific authority from a Commonwealth jurisdiction which suggested that sexual harassment is clearly a category of sexual discrimination. But how the tribunal was able to distinguish this case was to say that, and I quote, a lot of reliance has been placed on authorities from the UK which have interpreted material provisions of the 1975 SDA that are similar to the Act. In my opinion, however, limited assistance can be gained from considering what could or could not be done in the United Kingdom, which, unlike Trinidad and Tobago, has no entrenched constitution. So that, to me, is a very novel interpretation of the doctrine of stare decisis. So I'm not going to go any further. The rest is just a listing of these, as it were, worrisome trends in the development of the jurisdiction. And we live in hope that as time goes by, the tribunal will imbue a true understanding of how a human rights statute is to be interpreted. At the moment, we are in amicable discussions with the tribunal to sort out the question of the format of our reports, because the tribunal doesn't want to see our reports, and the question of how injunctions are to be dealt with during an investigation, because in the investigation, the matter has not as yet reached in court. So if it is that somebody brings a case at the investigative level, which requires an injunction, we are sorting out that maybe what we should do is write an emergency report, invoke an emergency jurisdiction on the tribunal. So we are working with the tribunal. Thank you.
Thank you very much, Ms. Simran. These are topics to which we spend entire semesters talking about, and entire books have been written about these various issues. So you will understand why both of us have been struggling to fit within the time. But now to our featured speaker, and I have great pleasure in welcoming Mr. Maraj to the floor.
Thank you very much. Good afternoon to everyone, all protocol observers, fellow panelists. I am deeply grateful for being invited to deliver the feature address on this occasion. You will appreciate that the topic, effective remedies for the contravention of human rights, would be close to the heart of any lawyer who was arrested and charged and imprisoned for contempt of court, and who got the conviction set aside, and then when he filed an application for redress, he was told that because it is a judge who contravened your rights, the Constitution did not provide any redress for the lawyer. So I was determined as the lawyer to see what the meaning of redress was. And I was very happy when it was decided that redress meant that you would have not only the declaration that your fundamental right was infringed, but you will also be entitled to damages. Now, in those days, which is when I was a little younger, in those days, when you succeeded in a constitutional motion, it was thought that your only redress was to get a declaration. And as the law developed, you then got damages, and then the damages were restricted, and then the whole principles of damages have changed over the years. What I intend to do this afternoon, in the time I have, is to try to show you the development of the law in respect of the remedies given under the Constitution for violation of fundamental rights. And having said that, however, I believe that when it comes to human and fundamental rights guaranteed in the Constitution, I think the state in all its arms, that is its executive arm, its legislative arm, and its judicial arm, has a duty to see that there are effective remedies for contravention of fundamental rights. And that is why when I was the Attorney General, I thought it best that the whole law of equality of treatment was a bit deficient, because all that you could have got in the courts was if there was a violation of equal treatment from the state or coercive powers of the state. So therefore, there was a violation of the right of equality by a private employer or a private individual, that would not have been possible. And the Equal Opportunity Act took a long time for it to be come into the form of an act, because you had to consult with everyone, you had to try and get consensus, and then, as you know from the history, the opposition did not support it at the time. And I think the Equal Opportunity Act and its history would show how important it is to have effective remedies for unequal treatment, one of the fundamental rights, but also for having it implemented in Trinidad and Tobago. Because as you were told, that when the act was passed, we had a problem getting it enforced. And then what had to happen, we had to get physically challenged persons and other persons who would have been entitled to redress under the act, to go to the courts to say that their right to the protection of the law was being contravened by the non-implementation of the act. And that battle led, as we were told, to the Privy Council, and the Privy Council ordered the act to be constitutional, declared the act to be constitutional, but also ordered the act to be implemented without delay. My starting point in my talk to you really would be section 14 of the Constitution. Now, as you know, when Trinidad and Tobago, like most of the other countries in the Caribbean, got independence, the written constitutions created a new remedy for individuals. That new remedy in Trinidad was in the section 6 of the 1962 Constitution, but I'm sure it is in many of the other constitutions. And that section or that remedy was that if any individual alleged that his right was contravened, was being contravened, or was likely to be contravened, that individual is entitled to redress. And the High Court must hear and determine his claim. Now that cause of action or that redress was without prejudice to any other right that the person may have. And therefore what happened is that as the Constitution was passed and the law was being developed, we had situations where persons applied to the court to get redress. And the important aspect of the development of the law already was what redress meant. And as you would notice from the cases, that you had a situation as to when someone filed a constitutional claim, is that claim being made against the state? Because if the claim was not being made against the state, you were out of court, because the fundamental right was only against the state, that is the executive, legislative, or judicial arm of the state. So you had the case of Thornhill, who was arrested. He was detained, and he was denied a lawyer. His request to communicate with a lawyer was refused. And the issue in that case was argued was that the police was not part of the state. The police service was not part of the state. And one of the great judges of Trinidad and Tobago, Justice Georges, decided no, the police was part of the state. But the matter had to go right up to the Privy Council. And it was held that the police was part of the state, affirmed that judgment, and then you had a situation in which that judgment then became the authority for a lot of other cases when you were dealing with cases. So then you had a case of Whiteman. That was a case where someone was held and he went into custody. When he went into custody, he was not told that he had a lawyer. When he was released, he filed a claim and he was saying that there was a duty on the police to tell me I had a right to communicate with a lawyer. And it's because of that case, you would see on most of the police stations now, if you have to go into the charge room, that there's something written that you have a right to a lawyer, and etc. So So, with the Constitution and to get effective remedies, we had certain provisions of the Constitution which were in the way, and at least one of them is still in the way. We have a section called the Existing Law Clause. What that clause said is that now the Constitution guarantees fundamental rights. In Trinidad and Tobago, those fundamental rights in the 1976 Constitution are guaranteed in sections 4 and 5 of the Constitution. What section 6 says, nothing in sections 4 and 5 shall invalidate an existing law, which meant that if you had unconstitutional laws before the Constitution came into force, even if they were unconstitutional, the court could not declare them unconstitutional. And that, to a great extent, prevented persons from getting redress for violation of their constitutional rights. Well, recently, the Caribbean Court of Justice has given a decision in a case. And in that case, it decided that that existing law clause is not right, it is not constitutional, it should not be there, because it is wrong to deprive the local judiciary of the right to declare a law which was made in colonial days unconstitutional. Now that decision, obviously, Mr. Mendes will help me. I understand it's going to be argued in the Privy Council in a short while. So it would seem to me, my view is that it is correct what the decision of the Caribbean Court of Justice is, because you cannot have an existing law clause in any case for an indefinite period of time. It must at least be for a transitional period, and long after a country has become independent. Why it is that you have this existing law clause preventing the courts from performing its role as guardian of the fundamental rights of the people. I should tell you this, only yesterday, in the courts of Trinidad and Tobago, there was a case in which I was involved in, and it is challenging the provisions of the Sedition Act. And one of the arguments I raised before the judge was that if the sedition law, or not the whole law, but if parts of the law, the impugned sections of the law, are unconstitutional because they are vague, because the law is vague. The law does not specifically say what conduct would amount to this criminal offense. If it is a vague law, it is not a law, because it offends the principle of legality. And if it is not a law, it would not fall within the existing law clause. Now, the matter has not been decided as yet, but that is an argument, I think, that if it involves, if you are challenging a law, which is a colonial law, and if the law is a criminal offense, it creates a criminal offense. If it is a vague law, there's a lot of established authority, even one from Guyana recently, which says that a vague law is not a law. Now, if you remember, before the case of Maraj and the AG, it was not thought that, it was understood that if the executive arm of the state violated a fundamental right, you can go and ask for redress. But if the legislative arm of the state violated your right, you could ask for redress. It was never conceived that if a judge violated your right, you could still get redress. So one of the important developments that was caused by the case of Maraj is that it made it clear that no one under the Constitution of Trinidad and Tobago is above the law. So even if a judge violated the Constitution, you cannot sue the judge because the judge himself is immune from liability, but the state is liable for the contravention by the judge of the fundamental rights. So one sees that how the law was developing in order to give redress And the redress included whether the executive arm violated the Constitution, whether the judicial arm violated the Constitution. And those of you who have studied constitutional law or who have we had to refer to it for some time, you would know of the case of the Trinidad Island White Cane Farmers Association in Trinidad, where certain sections of the Cess Act, which compelled cane farmers to pay a cess to a private organization, to pay part of its monies to a private organization, that part of the law was struck down as being in violation of the freedom of association and the right to the enjoyment of property. I want to read to you, some of you may know it, but I want to read to you some words that were said by Chief Justice Sat Sharma in the case of Ramnarayan Jor Singh and the Attorney General. And the reason I want to read it to you, it will give you a clear understanding of the impact of Section 14 of the Constitution, which gives the power of the court to grant redress. It gives you the understanding that the court basically has an omnipotent jurisdiction. And it depends upon the judiciary, it depends on the facts and circumstances of the case for the court to be able to give redress. As a matter of fact, the court is regarded as the guardian of the Constitution. And therefore, for effective remedies to be given by the courts, you would understand that in the countries which have these constitutions, there must be competent judiciary, there must be judiciary which has a passion in order to do, in order to give redress. Chief Justice Sharma said the breadth of the language of Section 14 is clear. The court is mandated to do whatever it thinks appropriate for the purpose of enforcing or securing the enforcement of any of the provisions dealing with fundamental rights. There is no limitation on what the court can do. Any limitation of its power can only derive from the Constitution itself. Not only can the court enlarge old remedies, it can invent new ones as well, if that is what it takes or is necessary in an appropriate case to secure and vindicate the rights breached. Anything less would mean that the court itself, instead of being the protector, defender, and guarantor of constitutional rights, would be guilty of the most serious betrayal. By way of amplification, I should like to add that there is nothing in Section 14 of the Constitution which limits remedies only to those known to law or equity, and nothing which limits the availability of existing remedies only to those circumstances in which would currently be available. So it gives you an idea of the scope and the width of Section 14. Now, if it is thought that you can only get a redress from Section, in respect of the violation of Section 4 and 5 of the Constitution, which guarantees fundamental rights, that is wrong. Because the Constitution provides that if any of the provisions of the Constitution, which are probably inconsistent or which are not being fulfilled, the court can grant a declaration. You would have seen recently there was a case of Dumas and the Attorney General of Trinidad and Tobago. In that case, the question arose as to whether the president acted lawfully in appointing members, I think, of the Police Service Commission. The issue was whether he followed the criteria in making the appointments. It was contended by Mr. Dumas that president acted unlawfully. He did not follow the criteria. He did not make the appointment in accordance with the criteria stated in the Constitution. Mr. Dumas filed an application in the High Court. The point was taken by the state that before the new rules came into force, you could have had an interpretation summoned, but that is no longer the case. And therefore, there is no locus standi in Mr. Dumas to, in order to bring this case. The matter went to the Court of Appeal, and in a judgment given, and Justice of Appeal Jamada gave one of the most brilliant judgments I've read in my disease in respect of the Constitution. He went through it, and in summary, what he said is that the Constitution, he said the courts have a duty to vindicate the rights contravened by the Constitution. It has a duty to uphold the rule of law. And as long as a person brings to the attention of the court a violation of the provisions of the Constitution, the court is the guardian of the Constitution. And the person doesn't have to show that his right was violated or the right affected him. He can come to the court, and it's up to the court to determine whether he has sufficient interest to file the proceeding. The matter went to the Privy Council, and it's a judgment I think both the Court of Appeal and the Privy Council you should read. So declarations given by the court, they are important tools for getting remedies, because let's say that Mr. Dumas, he got a declaration, or he's more likely will get a declaration in the High Court that is right, that the particular provisions of the Constitution were contravened. But that declaration does not only benefit Mr. Dumas, it benefits the public. So the declarations that you get in constitutional law would not only benefit the individual who's involved in the case, but it impacts the public rights also. So declarations are one of the ways in which you get a remedy for a violation of a fundamental right. Now, the whole question of damages. Well, I've told you already about Maraj and the AG. In Maraj and the AG, when the question came in the Privy Council in respect of what is the redress to be ordered, the claimant in that case, the applicant, took the position that he was not asking for exemplary damages or punitive damages. So Lord Diplock, in giving the judgment, he said since that was not asked for, he was only going to award compensatory damages. Then there was a case of Ronald James versus the Attorney General of Trinidad and Tobago, 2010 UKPC 23. And in that case, Lord Tolson, and paragraph 24 said the constitutional dimension adds an extra ingredient. The violated right requires emphatic communication. For that reason, careful consideration is required to the nature of the breach of the circumstances in which it occurred, and of the need to send a clear message that it should not be repeated. Frequently, this will lead to the conclusion that something beyond a mere declaration that there has been a violation will be necessary. This is not inevitably so. So we were getting the law developed that you were not only getting a declaration if your rights were infringed. The courts were now looking at the circumstances of the case to see whether you would also get damages. But the court was really only giving compensatory damages, not exemplary or punitive damages. But the breakthrough came. There was a case in Trinidad, Oswald Allen and the Attorney General. That was a case in which a lot of municipal police officers challenged, alleged that the right to the protection of the law was violated, and the matter reached the Privy Council, and then it came back here for assessment of damages. But the important issue in that case was the court had taken the position that because the damages would be speculative to assess, the court could not make an award for damages. So that was a case in which the state did not make a regulation, which it was supposed to make, for police officers to get access to the industrial court, municipal police officers, so that they could deal with their wages and etc. And there was the protection of the law the High Court said, and the Court of Appeal said that it was very difficult to assess the damages. It was speculative. What the Privy Council decided, however, was that it may be speculative, it may be difficult to assess, but you must give an award. So what the Privy Council said that where you cannot assess the damages because it is speculative, the court can give a vindicatory award. The court can decide the circumstances and give a vindicatory award. And before that case, you had the case of Ramanu, the Attorney General and Ramanu, in which the court, in which the Court of Appeal had given a majority decision that you could get vindicatory damages in constitutional law, and the Privy Council endorsed that. So now we have a situation where the remedies for the breach of fundamental right, you can get declaration, you can get damages, you can get punitive damages, which is the same as vindicatory damages, and etc. Another area in which the law has improved and the remedies have improved is with respect to injunctions. It used to be the law in Trinidad and Tobago that you could not get an injunction against the state in a constitutional claim. As a matter of fact, as a young lawyer, when I was doing one of the cases, Sunil Bansraj, the Court of Appeal refused me an injunction, but decided that you could give what is called a conservatory order, where both sides, the state has to give an undertaking, and the claimant, but the state has to give an undertaking that they would not do anything until the matter is determined. In other words, preserve the status quo. But you couldn't injunct the state. Well, all that has changed because there's a recent case of C. Prasad, which decided that both in the Court of Appeal and in the Privy Council, that you can get in a constitutional motion, you can get injunctive relief. And as you know, there are several cases which have decided, and the court has made mandatory orders against the state. The final area of the law I want to talk to you about. I think there has been a revolution in the law of the protection of the law. The right to the protection of the law is a right guaranteed in Section 4B of the Constitution of Trinidad. It used to be the law that it's only if you can show that the action of the law that you are impugning denied a person a remedy for access to the court, that will be a denial of the protection of the law. And there was a famous case of McLeod and the Attorney General. Well, all that has changed. The Caribbean Court of Justice, in the case of Maya Leaders Alliance and the Attorney General of Belize, has changed that, and this seems to have been followed by the Privy Council. And I'll just read to you what the CCJ said. It is a multidimensional, broad and pervasive constitutional precept grounded in fundamental notions of justice and the rule of law. The right to the protection of the law prohibits acts by the government which arbitrarily or unfairly deprive individuals of the basic constitutional rights to life, liberty, or property. It encompasses the right of every citizen of access to the courts and other judicial bodies established by law to prosecute and demand effective relief to remedy any breaches of their constitutional rights. However, the concept goes beyond such questions of access and includes the right of the citizen to be afforded adequate safeguards against irrationality, unreasonableness, fundamental fairness, or arbitrary exercise of power. So you see how the courts have enlarged the protection by merely developing the cases. And the Privy Council followed suit in the case of Jamaica for Justice versus the Police Service Commission, 2019 1 UKPC 12. The committee said the right to equality before the law, the protection of law, affords every person's protection against irrationality, unreasonableness, fundamental unfairness, or the arbitrary exercise of power. It seems that the Privy Council used the same word in the Caribbean Court of Law. So, my fellow colleagues, ladies and gentlemen, I have tried to give you a short synopsis of how the law has developed. if I may say so, I can tell you, I enjoyed doing constitutional law. I think that every lawyer who wants to take a shot at it is a very enjoyable. You will feel very energized and you'll like to do more. Thank you very much.
Thank you very much, Mr. Maraj. And if I might inject a personal note here, it's been a real pleasure hearing you. All of these cases which I teach very abstractly, hearing the personal dimension as well of that development, and the trajectory of that development was an added pleasure for me. So thank you very much. Ladies and gentlemen, we now have about 20 minutes for discussion. So you had some very intensive presentations. Mrs. Seabrand-Sweet gave you a very detailed overview of the Equal Opportunity Act and the remedy available thereunder, with some of the very specific and emerging issues around jurisdiction related to the Act. As well, of course, the issues you just heard around the constitutional Section 4 and Section 5 and Section 14, the Constitutional Bill of Rights in Trinidad and Tobago. So I'm sure there are lots of things that you might want clarified or might want to raise in discussion, and we do have some time for this. So we will welcome your questions. And there's a mic. Yeah.
Billy Ryan, Hamilton Davis is the one. Billy Ryan, Hamilton Davis, Trinidad Music. Well, can you hear me?
Sure. Yes.
Okay.
Online. Yeah.
Online. Okay. One of the questions I was wanted to ask from the our panel. We are seeing new laws like the Anti-Gang Bill, the bail bill, and these other bills coming up in Trinidad, especially on the opportunity. I would like to find out if there are any kind of concerns as far as prejudice is concerned for bills such as it's crime fighting methods, but there's also opportunity for prejudice because of geography, race, etc. So are there any kind of concerns of these?
So would you like to take a few questions? Someone or would you like to respond?
No.
Okay. Yes. So I think it might be useful if we take a few questions and then the panel will respond. Or we could. Yeah.
Okay. This is for the EOC chair. Can the EOC chair elaborate on what level of scrutiny of a complaint is done by the EOC before the complaint is permitted to be formally made against the respondent?
So yeah, if nothing else at this time, perhaps I could give the mic to Mrs. Sweet.
Yes. Well, the statutory duty of the Equal Opportunity Commission is to investigate the claim, and that usually involves scrutinizing the constituents of the complaint to make sure that the complaint falls within one of the areas which are employment, the provision of goods and services, education, or housing, and then to see whether there is a status ground. So that's the first level of scrutiny that we have to do. And once we get beyond that, then we send out requests for information from the other party to find out whether what is said by the complainant is true. Now, the complainants at that level are not represented by attorneys, and we are constantly interrogating our process to make sure that if there are any legal gaps that perhaps are in the complaint, because sometimes the complaint on the face of it doesn't show a status, doesn't show an area, or indeed the party may be the wrong party. So we are constantly interrogating our process to make sure that we give proper guidance to the complainants. But the thing is that we are not, as it were, representing the complainants. We are conducting an investigation and facilitating a conciliation process, so that it is really at the time of the conciliation fails and the matter has to go to the tribunal that lawyers specifically representing the complainant come into play. The other question, that question is going to be on there. I wonder if Mr. Mendes can answer that question.
Well, I can try to give you. So your question about the first, there are two things perhaps that I could say in response to that. And if I recall, you were asking particularly about the impact of certain new measures on disadvantaged groups. And I'll answer you more generally, perhaps that might be helpful, but just more in relation to the general principles. And the first thing I wanted to say to you is that equality or non-discrimination doesn't mean that everybody in the society has to be treated the same way. So the point of what I was trying to say earlier, we recognize, for instance, that people come from different starting points. People have different backgrounds. And so you might have to treat people differently in order to achieve a just outcome. And in any event, all states, all governments make distinctions between people. So I can give you some simple examples. Not everybody is taxed the same way. So it is recognized that if you earn at a higher level, for instance, you might have to pay more taxation. In terms of the provision of housing, for instance, in some countries there are programs that are of affordable housing depending on your income level, depending on the size of your family. So the point is that the law can quite justifiably make distinctions, whether it's based on income, whether it's based on social background, but you can treat people differently. Now, what the equality right does, or the non-discrimination right does, is to scrutinize the reasons why you might be treating people differently. And what it says is that if you are treating people differently, then the state must be able to justify that distinction. The state must be able to say that we are pursuing a legitimate aim. And this measure, this difference in treatment, is to achieve some larger social goal. So if, for instance, we are taxing people who earn more at a higher level, it's because of income redistribution, it's because you earn more, and so on and so forth. So I'm sure you get the picture there. So the point is, the state must be able to justify any distinction. And not necessarily in Trinidad, but in other countries where our right is more detailed, there are certain grounds where they are suspect automatically. So if you differentiate between people on the basis of race or gender or certain grounds, then those are automatically seen as impermissible grounds. In other words, they have no relation to anything, no social good. There's no logical reason to differentiate between people on the basis of race, for instance, or ethnicity. All right, so that's the starting point. Now, so the other dimension to your question, if legislation has effects which are perhaps disadvantageous of certain groups, I think this is where the point of my presentation was about substantive equality, in that the right to equality is not just looking at procedural fairness or treating everybody the same way, but looking at the outcome. And so if specific legislation is impacting differently on people because of impermissible reasons, then I think a more substantive look at equality might say then that kind of treatment is impermissible, because ultimately the multidimensional way that I was saying that we should look at it is about full inclusion of all people in society, and particularly trying to redress historic disadvantage. So that's a long way of me saying that it's okay to treat people differently, but the state must be able to justify that. I hope that helps you. You might not hear my thing, but it's for the online.
All right, so good afternoon, everyone, and thank you for your very informative presentation. The question is for Ms. Ramsey. You indicated that you submitted that the Equal Opportunity Act is a human rights statute, sorry?
Yeah.
And should be interpreted broadly and purposefully, and not as narrow as it's currently being interpreted.
In one or two cases,
Right.
in some cases.
Right. And I agree with you completely. And so I want to tie it also to the discussion on substantive or substantive equality, because Trinidad and Tobago, as you know, is a signatory to the CEDAW Convention. And at the core of the CEDAW Convention is substantive equality. So the suggestion is that while we are acceded to a convention which at its core is substantive equality, we are still putting forth laws or acts like the EOC or the Equal Opportunity Act, which is arguably not. So how do you ended your presentation by saying the hope for true understanding of the interpretation of human rights statutes is where you are as a commission. And I'd like to understand what steps that will be put in place to move from hope to actuality.
But one of the slides, I think, in my presentation that I don't recall addressing specifically was the question of the functions of the Equal Opportunity Commission as set out in Section 27 of our Act. And those functions are, first and foremost, to promote equality and non-discrimination in Trinidad and Tobago. Secondly, to do research and advocacy. Thirdly, to keep the legislation under review so that the government can be advised of amendments as they become necessary from time to time, and to publish guidelines. So whilst the core function of the Commission may be considered to be to receive, investigate, and conciliate complaints, and then to initiate proceedings in the tribunal if the conciliation does not succeed, the Commission has a much broader advocacy function, and we try our very best to fulfill this advocacy function. For example, in our annual report for the year 2018, you will see that for this year, we have had, I think that the figure is something like 25 or 26 separate outreaches to various corporations and statutory bodies who want to understand about the remedy. So very much what we are trying to do is advocacy, research, advising government on policy changes, and at the moment we are operating in two ad hoc committees with the Attorney General. One of them is an ad hoc committee which addresses generally all of the amendments to the Equal Opportunity Act that we've been advocating for over the years, the broadening of the definition of sex to include sexual orientation, the inclusion of age discrimination, the inclusion of HIV as a separate status and not in regard as regards it being considered a disability, that sort of thing. So that is one committee that we're working on. The other committee is a specific committee to deal with the recent unfortunate decision, which was that sexual harassment is not a category of sex discrimination. So we are working with another ad hoc committee of the Attorney General, along with a number of NGOs, to move the Attorney General to codify the Act, the Equal Opportunity Act, and indeed to have standalone legislation which defines what sex discrimination is, what discrimination is, and to clearly state that there is a remedy both in the Equal Opportunity Commission and in the labor sector, where already you have sexual harassment being able to be litigated in the Ministry of Labor and in the Industrial Court through unions and employers. So we're very much working, and this kind of outreach is a part of the work that we are doing, where we want to continue to analyze the jurisprudence as it develops with a view to encouraging really a more liberal approach to the question of how do you interpret a human rights statute.
If I may follow up, just to follow up on that.
Yes.
Do you see the value then in, thank you, if I may follow up, just quickly, do you see the value then of having a human rights institution included in the Equal Opportunity Commission, so that there is a body that actually addresses issue from a human rights perspective, as opposed to it being ad hoc?
Thank you so much for raising that, because before I pass on to, don't you take what a National Human Rights Institution, that's the acronym, NHRI.
Yeah.
So that the United Nations throughout the world has been encouraging countries to have a national human rights institution, which is operating along what are called the Paris Principles, which are that the institution must be independent and it must partake of certain other characteristics. And one of the strategic goals which has been established in the strategic planning exercise of the Equal Opportunity Commission is that the Commission is aspiring to be this national human rights institution. So that, of course, there needs to be a political will for this to happen. There needs to be an understanding in the population and among civil society of the need for such a national human rights institution. The Equal Opportunity legislation already creates a human rights jurisdiction, but as to whether we can qualify under the UN criteria to become a national human rights institution, we are on that trajectory, and we have already approached the United Nations head of mission. Somebody is going to be hired for the purpose of assisting the country along those lines, and the Equal Opportunity Commission is very much in the running for this. Not only from the point of view of what we already do, but also from the point of view of the proper utilization of resources. What's the point of setting up another commission if already there's a commission with this mission, with this establishment, an establishment of attorneys, investigators, researchers, communicators? It may very well involve an augmentation of our board, an amendment to our act, the achievement of full financial autonomy and independence, because we currently operate as a department of the Attorney General, and in that is built a little contradiction, because we receive complaints against ministries. So we see there's a little, and the legislation itself provides for us to be independent. But so we working.
Thank you.
I just wanted to add something that may help you in your representation to the government. I think that we are dealing with legislation which was very difficult and see for Trinidad and Tobago. But Mr. Mendes can help me. I think there is a decision of the courts that where you have an international treaty which the country has acceded to, you can argue that there is a legitimate expectation, so that in your representation to the Attorney General, you can probably point out that all the matters, as long as it fall under a treaty or convention which we have acceded to,
Yes, it's the seal.
right? So there's an expectation that the government will take steps to amend it in order to.
Yeah, we are prodding, we are working with the Attorney General all the time.
Do we have a question online?
Yes. In circumstances when specific comparators are identified or alleged, how does the EOC balance a third party's rights to privacy in relation to the protection of the third party's data or information with their investigative function?
Well, our process is supposed to be confidential, And the only time at which our process becomes public is where there is not a result from conciliation, and we have to publish a report which under the Act must be made to the public. So in terms of the data of private persons, the question is it that the data of private persons should be, who are not parties to the complaint, should be kept private, that should be kept out of the reports. It's the first time that I'm addressing my mind to that, and I will certainly take it up with my cadre of attorneys and the board as to, whether that is something that we need to look at. Well, because there are ways of protecting the confidentiality of persons who must of necessity be mentioned in law reports, in public reports, and that sort of thing. The use of initials.
There's a second part to the question. Is the POC limitless in the type of information it can request from a respondent in relation to a third party comparator, where the third party would not have given the respondent their consent to share their personal data or information?
Well, is the third the responsibility to provide the information is on the part of the respondent. So if it is that the complainant has made an allegation that they are being treated unequally or in respect of a comparator, it is the employer, the respondent, who has to come forward and give that information. I do not see that in that context, the third party, the comparator, who is the beneficiary of the discrimination. I don't see that they can have a right of privacy. In any event, this whole question about right of privacy is something that is a bit, it is frequently said that at common law, there is no right to privacy. Now that basic common law principle has been being eroded over time by various statutes and so on, especially with the advent of social media. And there are many remedies that are being created, not least in the case law in Trinidad and Tobago, where there's a judgment of Justice Frank C. Prasad, where he declared that there was a wrong was committed where, what is it called, when your former partner, revenge porn, right? So revenge porn, for example, is wrong. But I don't think that anybody has an absolute right to privacy if that means that it's going to deprive somebody else of a remedy.
I think the one thing I would want to observe, which of course wouldn't be up to you, but it is that these questions, I think, highlight the challenges of this very formal approach to equality, and particularly this requirement of a comparator. Again, the whole requirement of a comparator, which is basically saying this is somebody who's similarly situated but treated differently, assumes that there's a universal standard against which everybody can be measured, and that's often the starting point that's problematic. The other thing is that standard tends to be the standard of the dominant group, and there are a host of other issues with it, of course, but I do think this is why this multidimensional approach that I was talking about tends to look beyond this and tends to say, well, we're not just simply seeking to compare people, but we're looking to remove disadvantage. And the formal approach and the preoccupation with the comparator is really about saying let's treat everybody the same. And often it really is too simplistic. Often it means focusing. In fact, the differences that we talk about are very nuanced in terms of group identity. what I think equality tries to aim at is to get rid of the prejudice associated with group identities, but not necessarily to get rid of all difference, because difference is what enriches us, which is what Justice Saunders started out by saying in the McEwen case. And so a more substantive look at equality is saying, let's get rid of this, of the detrimental effects, but let's also understand that difference is something that could enrich us, and move away from simply comparing, which often, as I said, can mean leveling down. So I mean, these are very, I know, very complex and underdeveloped issues in our jurisprudence. But my main plug is that we have to think beyond formal equality. Not sure if there are any more questions, but I do think we are out of time. So what I just wanted to say in closing was that there was a lot of information here today. I hope it was beneficial to you. What the EOC and the LATT tried to do was to give you, sorry to use this again, but a multidimensional look. So Mr. Maraj in his feature address, who looked at the development, the historic and current developments of the constitutional right. And as he pointed out, a right which was really directed at the state. And in fact, it was his case which sort of set that trajectory, the Maraj case in the very beginning, when they said, look, we're talking about state action. But therein lay one of the big deficiencies, because the state is a big element of any society, but private employers as well. And that's where the Equal Opportunity Act in Trinidad and Tobago came about to redress, and similar legislation which exists in other parts of the Caribbean. And Mrs. Sebran-Sweet's presentation was about, I suppose, this underused remedy. And so giving you the other side, this equal opportunity legislation, which allows you then to bring, to challenge, including in the private sphere. Including in the private sphere. And I suppose what I was trying to do as well was to introduce this notion of the difference between formal and substantive equality, and how ultimately substantive equality is aiming not just as treating people, not simply or merely or only treating people like as alike, but taking ultimately a deeper look at this and saying what we want is full inclusion, full participation, redressing disadvantage. So thank you very much for so keenly listening to us. Thank you for your engagement, and thank you most of all for being here. And thank you, Mr. Maraj and Mrs. Sweet, for your presentations.
Yes, I think that Mr. Mendes will say a word, and then Mr. Burkan, Dr. Burkan, you have a responsibility to invite the participants for refreshments after.
So it seems Mrs. Sweet has taken over my responsibility, but there are refreshments after.
Yeah. Okay.
I have, my role is just to move forward. Thanks, first of all, to Dr. Burkan for reminding us about the important distinction between formal equality and substantive equality. There's a cartoon that I've seen because which illustrates that principle very vividly. Wow, a tall person, basketball player, 7 foot tall, a 6 foot person, a 10-year-old boy, girl, 4 feet tall, all trying to see over a fence. Formal equality requires that you give each of them an identical box to stand on so they can see over the fence. But substantive equality means that the tall person doesn't need a box at all, whereas the short person needs 2 boxes, so that all 3 of them can see over the fence at the same time. And of course, related to the question of right of access to the court, everyone in Trinidad and Tobago has an equal right of access to the court. But if you're a wealthy person, you can afford a very good lawyer like Mr. Moran to take your case to court. If you are poor, then right of access to court means something. And thank you very much to Mrs. Sebran-Sweet for reminding us as well about the remedies that are available for the Equal Opportunities Commission, and also pointing out to us the difficulties that are being experienced in some instances with the narrow interpretation of the provisions of the Act. of course, the whole idea of the Equal Opportunities Act, as Dr. Duncan was pointing out, was to extend remedies for violation of fundamental rights, in particular rights to equality, to non-state actors who will be violating those rights. Because, as Mr. Raj pointed out, the human rights remedies are available under the Constitution, are only available to the coercive arm of the state. Thank you, of course, to Mr. Maraj for pointing out to us that first of all, it's no point having any rights under the Constitution at all if you don't have effective remedies, and also pointing out that there have been very important developments over the years to the point where you have some rare remedies that are being handed out to successful litigants for violation of their constitutional rights. Of course, Mr. Maraj was also a victim of discrimination when he was cited for contempt because of his unique ability to present some cases effectively on part of his clients, and maybe now and then they irritate the judge. So in that respect, he was treated unequally. But also thanks for reminding us of the Thornhill and Whiteman cases, of the rights to be represented by a lawyer, and also the right to be informed of that right, because apparently there's someone who thinks that the exercise of that right is responsible for the murder. Thank you as well for you for turning out today in your numbers. For those of you online who I can't see, but you can see me, for turning up today to make this important event, and for all of the questions you have asked. Thank you very much to the staff of the Law Association of Trinidad and Tobago and the Equal Opportunities Commission for all of the work that you put out in making this an enjoyable and informative event. Thank you all, and I will relieve Dr. Balkan of the responsibility to tell you when there are refreshments outside.
Okay.